Start with case number 51 MCQ first. What is the residential status of Anuradha as per the provisions of FEMA for the financial year 2015-16? So for finding out the residential status of Anuradha, we have to see what is the number of days she has lived in India. So as per the case study, she got placement in US based company. She joined the ABC Limited at Boston on 1st September 2015. Okay, so she has lived in India from 1st April 2015 to 31st August 2015. Okay, so for this we have to see what is the uh, definition of person resident in India. Okay, so according to section 2 subsection 5 of the FEMA, a person residing in India for more than 182 days would be considered as person resident in India. Okay, so since she has lived only for 153 days, which is less than the minimum requirement of 182 days, she will be considered as person resident outside India. Okay, next question second. Mohan used his international credit card in making various payments when he was in Boston. So for this, if you know, there is a provision in FEMA which says that a person can remit up to 2,50,000 US dollar without any approval of RBI or any other authority, but there is no any limitation on using international credit card for making the payments. Okay, so Mohan has used his international credit card for making various payments when he was in Boston. So yes, A is the correct answer because he can use his international credit card without any approval of RBI. Okay, next would be question third. Dr. John was planning to purchase a flat in Mumbai. Whether Dr. John, not being a Indian citizen, can buy a flat in Mumbai. For this also we have to refer the case study. Okay, so this sentence is very important because it says that Dr. John was planning to purchase this flat in Mumbai in the joint name of Anuradha. Okay, so after reading this, you have to be sure that it is the regulation 6 which they are talking about. So according to regulation 6, if any person wants to acquire a property in India in the joint name of him and his NRI spouse, NRI or OCI spouse, then there are certain conditions that needs to be fulfilled. Okay, so regulation 6 of FEMA, which says that a person resident outside India, that is Mr. John, can acquire a property in the joint name of his spouse of NRI if provided that the marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the acquisition of property. Okay, so here we have to see that Dr. John and Anuradha finally got married. They got married in the month of September 2016 and they had come to India to Mumbai on 20th October 2016. Okay, so as you can see, they got married in September and they have come 2016 and they have come in India in Mumbai to on 20th October 2016. Okay, so 2 years have not elapsed from the date of their marriage, so they cannot acquire property in the joint name. Okay, so option B is the correct answer because no, he cannot buy a flat in Mumbai since 2 years has not elapsed of his marriage with Anuradha. Okay, next question fourth. What is the notice period under section 13 subsection 2 of the SARFAESI Act, after expiry of which the bank can take possession of the flat? Okay, so this is a very straightforward question. If you know what is the number of days, you will get the answer. So for this we have to refer the answer. Okay, so section 13 subsection 2 says that any borrower who is under a liability to a secured creditor under a security agreement makes any default in repayment of secured debt, then such debt will be classified as non-performing asset and secured creditor may require the borrower by notice in writing to discharge in full his liability to the secured creditor within 60 days from the date of notice. Okay, So once a borrower's account is classified as NPA and notice has been sent to him, within 60 days he has to make the payment. Otherwise, within 60 days of the date of notice, otherwise bank can take the possession of the flat. Okay, so option C is the correct answer, 60 days. Okay, so question 5th, under the provisions of RERA, how much amount can be taken as an advance at the time of booking of the flat? So this question has been asked in so many case studies. By now you must have learned this answer. Okay, so not more than 10% is the correct answer, because that is maximum amount of advance that can be taken by promoter would be 10% of the uh, 10% of the cost of flat. Okay, so option B is the correct answer. So in this way we have completed our discussion of case study number 51. Thank you.